Good morning, everyone, and thank you for joining us for today's session, where we'll be discussing the first-tier tribunal, outlining the tribunal process and explaining the jurisdiction of the first-tier tribunal. My name is Stephen Smith, and I'm delighted to be joined once again by Ian Quayle and my colleague Robert Kelly. Good morning to you both.
Good morning, Stephen. Good morning, everyone.
Good morning. Just before I hand over to Ian, just like to go through a few items so you know how to participate in today's event. You are listening through your computer's audio system by default. If you would prefer to join over the phone, you can just select the telephone option in your audio pane and dial-in information will be displayed. I have it on good authority that it's a very good reception. We have some colleagues of ours from outside of the UK that log in as well. And so, yes, the reception is good on the telephone and it is toll-free as well. In terms of the session, you will have the opportunity to submit text questions to both Ian and Robert by typing your questions into the questions pane of the control panel. You can send any questions anytime during the presentation, and we'll collect these and address them at the end with a designated Q&A session. You can also raise your hand during the presentation if you're having any difficulties with the sound or other technical issues. And also, if you would like to ask a question directly to Ian or Robert or myself, then you can also do that. Please just raise your hand, let me know that you want to speak, and we can unmute your microphone. We will also be running a poll at the end of today's session, but we are wary that the budget is at 12:30, so we will try and keep the session well within those time limits. Anyway, without further ado, I'll pass on to Ian for the main part of the presentation. Thanks, Ian.
Thank you, Stephen. Thanks, everyone, and good morning to you. Thanks for coming along. Yeah, Stephen said today what we're going to do is look at the first-tier tribunal from the perspective as a transactional property lawyer. What do we need to know about and what is relevant? What I've done is divided my presentation into two distinct parts. Firstly, looking at the first-tier tribunal in connection with land registration, which ties in quite neatly with some of the things we've looked at in the past, and then to look at the role of the first-tier tribunal predominantly from a leasehold context, to have a look at what it can and can't do. There's also within the notes and indeed within the slides some issues relating to procedure. The reason I've done that is that sometimes transactional property lawyers will think, well, the tribunal isn't proper litigation, and either they will have a go at the tribunal application or more commonly sort of get embroiled in the workings of the first-tier tribunal, sort of hand-holding on behalf of clients. And again, that is admirable in some respects, but also potentially dangerous. I will be flagging up some of those dangers as we progress. So lots and lots of things to talk about. There are some extensive notes that are available. The slides can be made available too. And as Stephen was saying, happy to take questions as we progress or when we finish. The first thing to do is just to remind you about useful websites. Leasehold Advisory Service in particular has a wealth of material about the jurisdiction of the tribunal, about applications that can be made. On that site, there are precedent forms and guidance notes in connection with everything that we'll be touching upon. Leasehold Knowledge Partnership, not so much materials, but interesting information about what landlords are doing and not doing, giving you a flavour of the sorts of things that generate problems for landlords with regard to first-tier tribunal applications. And then, of course, the government website contains information about the lower tribunal and upper tribunal in connection with residential property tribunal jurisdiction. So, as far as the residential property tribunal is concerned, it has a very vast range of different issues that it can deal with. Everything from objections in connection with land registry applications to fair rents and market rents to disputes with regard to determined boundaries at the land registry through to your traditional sort of landlord and tenant dispute concerning defective leases, the right to manage, enfranchisement, administration charges, service charge disputes and the lot. We will be scampering through most of those issues. Important to understand from the first issue that I really want to delve into, the first-tier tribunal has a jurisdiction to deal with land registration issues. It is called the Land Registration Division of the Property Chamber, and is in fact part of the first tier tribunal. When we talk about objections, generally speaking, there's a quite wide jurisdiction to deal with any objection relating to applications that are made to the land registry. And it's important to understand the interface between the land registration and land registry and first tier tribunals, and what tribunals can and can't do. There are some sort of basic themes with regard to the land registration division of the property chamber and the work of the land registry. The first thing is that the land registry itself will act as a filter with regard to objections that are made to applications made to the land registry. If the land registry's view is that an objection is groundless, then the matter will simply be put to one side and the application dealt with. Where the application appears to have some merit, then there are a number of steps that the land registry can direct the parties to undertake. The common thing is, and the most important thing to be aware of, is that the land registry has a system that allows the parties to negotiate and gives them freedom and time to do so. But the land registry may also make a direction to a party to commence court proceedings, as can the first tier tribunal. It can, as far as the tribunal is concerned, make a direction to determine disputes without a court hearing. And significantly, as far as the opportunity to negotiate is concerned, the land registry imposes a regime with regard to the negotiation process. So as far as that regime is concerned, I want you to take you through it just to have a look at what the position can be. There is a 6-month negotiation period allocated by the land registry, and the parties can veto that and ask for the matter to be dealt with by tribunal. If the 6-month negotiation period is chosen by the parties, then the land registry will maintain a watching brief relating to that process. It will, in those circumstances, intervene after 3 months to see how the negotiations are progressing. It will then communicate again after 5 months, and in those circumstances, if it appears that negotiation has not achieved any form of settlement, the land registry will then ready the matter to go before a tribunal by preparing, and I mentioned this in the notes, a case summary. Any of the parties during the negotiation process can ask the first tier tribunal to intervene with regard to that process. And important and significant, the negotiation process regulated by the land registry is relatively informal. It is only when an application is made to the tribunal and tribunal proceedings begin does that generate issues concerning costs and the availability of withdrawal. So let's just have a look at an example here. Let's assume there's an objection that is lodged in connection with a unilateral notice, a challenge that's made. Let's assume the parties are given an opportunity to negotiate. The applicant for the notice is adamant that he has an interest in land. The registered proprietor is adamant that he doesn't and doesn't want the unilateral notice on the title. In circumstances where a negotiation achieves nothing, either party can immediately apply to tribunal. Where negotiation is achieving something, you've got this 6-month period with the land registry intervening at intervals. If at the end of 6 months we haven't got any progress, then the matter will be referred to tribunal. The land registry can express views as to the merits of the application for notice or the grounds for objection. They're perfectly entitled to do that. The parties are free to accept the advice that the land registry give or to ignore it. Significantly, any findings, any views of the land registry are not binding on the parties. Important to understand that, and also important to understand that neither the tribunal nor any county court or high court judge will see any of the views, any of the communications from the land registry with regard to the dispute. Important to understand that if you're acting for either party in connection with a dispute, be careful about any inadvertent disclosure of the stance taken by the land registry with regard to the negotiation period. I mentioned in the notes that communications or supporting documents submitted to the land registry are dealt with differently. And these can be available to both tribunal and also to the courts. The position is that even if correspondence or communication that is relevant is marked confidential, then the position is disclosure can still take place. So in those circumstances, if you are submitting information or documentation or contemplating doing so to the land registry, be aware that that documentation may find itself in front of a county court judge or in front of a tribunal at a later date. So this idea of an opportunity to negotiate is good. Some would argue it's sort of a paradise for someone who wants to prevaricate and delay. Remember that there is a right of veto. If I'm on the other side of a matter and I think you're just drawing this out in the hope that sort of by way of attrition, I'm going to go away, I can always say to the land registry, no, I want this matter referring to tribunal. And the tribunal will, in those circumstances, intervene. The other thing that's important is whilst the negotiation process can be relatively cheap, and a lot of practitioners do think first-tier tribunal applications are relatively cheap and inexpensive, and that there aren't any real cost issues arising, that isn't the case. The moment that you apply to a tribunal and the tribunal commences its process, one, you can't unilaterally withdraw, and two, there is a vulnerability as to costs, as we'll see a little later. It is important to understand this last point that I've just mentioned on the slide here. Withdrawal. There have been applications in the past where someone has tried to extricate themselves from the tribunal process, and the courts and tribunal have confirmed you can't do that unilaterally. You can do it by consent. If the parties reach an agreement, that would be a sensible thing to do. But all of a sudden, if your client or you get cold feet with regard to an application, a sort of easy withdrawal with no liability for costs isn't necessarily on the cards in any way, shape or form. So as far as the tribunal is concerned with regard to land registration, I've given you some details. I'll just go back to that slide if I can. In addition to that, it is possible for the land registry to determine boundaries, and I've given you details relating to it. Remember, I've spoken to you about determined boundary applications in the past. Determined boundary applications are a marvellous fix in circumstances where we have a situation where there is agreement as to where a boundary is. On the other hand, where there is disagreement, the land registry will refer the matter to tribunal. And the processes that I've just alluded to with regard to objection will be the processes that are utilised by the land registry in the event of a dispute. Okay, so two things I think to follow. One, if you're making a contested determined boundary application, you will find yourself before a tribunal or a county court in most circumstances. Two, as far as that process is concerned, it's going to be slow. If there is consent with regard to a determined boundary application, the procedure is normally swift. If you are doing anything other than that, the application process is likely to be very slow indeed, on the basis that you are waiting for a tribunal or waiting for the court process to proceed and to deal with the problems or issues that are encountered. Determined boundary applications, remember what I've said to you in the past, the boundary dispute protocol on the property protocols website contains all the information that you need. The next thing to look at are first-tier tribunal jurisdiction in connection with residential leasehold disputes. And the number of points here. Firstly, the first-tier tribunal property chamber was established in 2013. And it includes the old rent assessment committees and the leasehold valuation tribunal. So it has wide-ranging jurisdiction, in addition to dealing with disputes concerning agricultural land and disputes concerning land registration issues as well. The residential property tribunal, dealing with leasehold disputes, is the largest part of the chamber and deals with occupational disputes between landlords and tenants, freeholders, leaseholders, park home occupants, as well as local authorities. So it has a wide remit. the adjudication of property cases is in essence split between the residential property tribunal and the county court, and there is a degree of flexibility as between the two. So the county court has jurisdiction to refer matters to tribunal and vice versa. A residential property tribunal is an expert tribunal. You'll normally have lawyers or surveyors who specialize in the field sitting on the tribunal panel, and it is important to understand that as far as the tribunal is concerned, it has fairly wide-ranging powers as to what it can and can't order. It can ask that cases are dealt with on the papers by way of written representations. It can ask that matters are dealt with by way of hearing, and more telephone conferencing, video conferencing is used in connection with the first tier tribunal. The written representation process is quite useful from a perspective of saving costs. There are some other issues with regard to costs that I'd like to sort of dwell on just for a moment or two. If you are dealing with any sort of first tier tribunal that concerns landlord and tenant issues, so for example, if we're looking at service charge, if we're looking at administration charge disputes where other leaseholders are involved, it is imperative that right at the start of the application or the process, you get those other interested parties involved. If you don't, the tribunal is likely to adjourn the process and invite others who are concerned with the application to participate. There will be a delay. I also mentioned in the notes that the Tribunal Courts and Enforcement Act 2007 establishes the system and process with regard to the work of the tribunal, and the tribunal has practice directions and rules. The Tribunal Procedure First Tier Tribunal Property Chamber Rules 2013 confirm how the tribunal operates. There is a need for familiarity when you are embarking on applications to tribunal. So let's have a look now at what sorts of things the tribunal can deal with. First of all, as I mentioned here on slide, Leasehold Reform Act 67, purchase of freehold or extensions of leases for residential houses. Remember, I refer you again to the leasehold pledge. These days, what you're seeing is far fewer applications of this nature when dealing with the sort of major builders, property developers, on the basis that they are geared up to assist with regard to freehold purchases or lease extensions for residential houses. Someone sent me an email last week and said, you know, what would you advise a client where the client is in a position to extend the lease for a residential house as opposed to purchase the freehold? And the advice must be purchase the freehold. It makes far more sense, of course, subject to the leaseholder being in a position to pay the appropriate purchase price. It is possible for a tribunal to impose conditions on purchase or leasehold extensions, and it's also possible for a tribunal to determine a landlord's reasonable costs. To that end, if you want a sort of guide or a framework as to what sort of costs are deemed to be reasonable, the Leasehold Advisory Service has a library of tribunal decisions, which gives you a flavour of what the tribunal's thinking is relating to costs. Quite a useful exercise in connection with any application concerning residential leasehold disputes, to have a look at what the tribunals have decided in the past, and the easiest way of doing that is to go to the Leasehold Advisory Service library. There's a relatively simple search engine that enables you to determine types of application and then look at what the tribunal has said with regard to costs issues. We've covered that. Service charge. Service charge disputes are undertaken before tribunal and constitute a large raft of the work that they do. Landlord and Tenant Act 1985 is relevant law. The tribunal has jurisdiction to determine the reasonableness of service charge, the liability to pay service charge, but significantly does not have jurisdiction to give leaseholders time to pay. In determining reasonableness of service charge, a tribunal will look at the works that have been done. Was it reasonable to do them? Were the works done to a reasonable standard, and were they done to a reasonable cost? There's also a requirement for a landlord to supervise the works to a reasonable standard as well. In determining reasonableness, interesting point, the ability of leaseholders to pay is not currently an issue. So a leaseholder cannot say in determining the reasonableness or otherwise of service charge, the leaseholders in this block of flats cannot afford to pay the amount that's being charged. Okay, that would not be a factor for determining reasonableness. So when you're looking at service charge issues in residential leases, the first thing that you're doing is you're looking at the lease itself. What does the lease enable the landlord to recover? What services does the lease require the landlord to provide? If the lease is silent on both of those points, or either of those points, then the landlord can't recover cost. And remember, service charge is the recovery of cost. A landlord cannot generate profit unless the lease enables the landlord to charge management fees. The 85 Act allows the tribunal to apportion service charge. Interesting point there, where the lease allows apportionment, but the apportionment is always less than 100% or more than 100% of cost, that would mean the lease is defective. That would enable an application to be made on the basis that the lease is defective, and we'll talk about that in a moment or two. The Commonhold and Leasehold Reform Act 2002 adds a further coat of paint on the jurisdiction of the tribunal with regard to the 85 Act. Because what it imposes is, first of all, the consultation process. A landlord must consult with leaseholders where the landlord is incurring a cost of more than £200 per leaseholder in connection with ongoing service charge contracts that last more than a year. If he fails to do so, then the amount of service charge that is recoverable is capped. In addition to that, the Leasehold Reform Act 2002 allows a tribunal to determine the costs that are recoverable within service charge, and also to limit recovery of tribunal costs within service charge. By that I mean, and this is a key point today, if you apply to tribunal in connection with a residential leasehold dispute, and if the landlord either does not seek its costs or is not awarded its costs, then historically what a landlord would do would recover those irrecoverable costs within service charge. The Commonhold and Leasehold Reform Act 2002 amends the 85 Act, allowing a leaseholder to seek an order of the tribunal that the costs that the landlord can't recover from it cannot be put into service charge and recovered from other leaseholders. It's something that those that are dealing with tribunal work on a regular basis are aware of. Those of us that are not that used to tribunal work, or where we're dealing with or assisting or hand-holding clients that are making applications themselves, it's something to draw to the client's attention. It protects the client and their fellow leaseholders from the landlord recovering service charge via an alternative route, rather than the tribunal simply making an order for costs. So this means the tribunal makes an order that the costs that have been incurred in the tribunal dispute cannot be recovered within service charge. And the tribunal also has jurisdiction to dispense with landlords' obligations to consult. Second important point on this slide that I want to emphasize. The consultation process in the Commonhold Leasehold Reform Act 2002 is designed to protect leaseholders. It requires them to cooperate and communicate with the landlord with regard to the decision-making process concerning service charge. It is possible for a landlord to apply to tribunal to dispense with the obligation to consult. There is a proper way of adopting that process and an improper way. Let's look at the proper way. A landlord can ask the tribunal, before he begins the process of incurring a cost, for dispensation. The obvious example being block of flats in central London, problem with the roof leaking dramatically. The consultation process to run through properly is going to take 2 to 3 months. In the meantime, the block of flats is leaking like a sieve. Landlord can ask the tribunal to dispense with the obligation to consult to enable the landlord to do the works straight away. The tribunal will take into account whether or not there is any disadvantage or prejudice to leaseholders. The normal stance is anything that does not enable a leaseholder to participate in the consultation process is prejudicial to leaseholders. Only where the risk of delay and damage to the building is even more prejudicial will dispensation be awarded. Where I see dispensation applications being made in error is a situation where a landlord has failed to go through the consultation process, realizes when the works are done that it's fallen foul of the 2002 Act, and then asks for dispensation. Well, the problem there is the tribunal is likely to say the leaseholders are being prejudiced. They haven't participated in this process. Where there's been no attempt to go through the consultation process, the tribunal seems to be saying you can't have dispensation. Your service charge recovery is capped. Where there's been an effort to comply with the consultation process and some minor irregularity, then what I'm seeing is the tribunal granting dispensation in those circumstances. Now, there is an issue from a landlord's perspective with regard to consultation, and that is this. What is the position if I'm a landlord and I think that costs that I'm going to incur are going to be less than the ceiling prescribed by the Common Home Leasehold Reform Act 2002? So I've got some quotations in for works that mean each leaseholder is going to have to pay £150 or so. What is the position in circumstances where the landlord starts the work, completes the works, is just about to complete them, and then contractor says, oh, by the way, we found X, Y, and Z that needs addressing? Well, what's the position in those circumstances? Well, again, in that situation, there would be a requirement for the landlord to go through the consultation process or to seek dispensation. But it's a very brave landlord that does nothing. That's the point, really, I want to make with regard to that slide. Insurance. Landlord and Tenant Act 1985 enables application to be made to tribunal where there is unsatisfactory insurance provision within a residential lease, or where insurance premiums are being charged that are excessive. Again, as far as that is concerned, these applications tend to be relatively minor applications, and frequently you'll see leaseholders making the applications themselves. If that is the case, again, it's important, if you are sort of hand-holding a client or you're aware that a client is embarking on proceedings relating to insurance, it's important to ensure that what we're doing is we're telling the client about the process with regard to tribunal, and again about vulnerability relating to cost. Absolutely essential that we do that. Again, really, it goes back to a point that I've made to you in the past with regard to transactional work. You know, either we're advising you, the client, in connection with the tribunal application, or we're not. There isn't a sort of halfway house. If you are sort of thinking, well, I'm doing some hand-holding, the halfway house type of scenario, be careful to make sure the client is properly advised about process and about vulnerability. The right to appoint a manager under the 87 Act, again, is subject to the jurisdiction of tribunal, as is the defective terms in residential leases of flats, more on that in a moment or two, to decide the purchase price following an acquisition order in connection with collective enfranchisement, and to determine the price to be paid on an application under the right of first refusal. All of these types of application are more complex than the ones that we've just looked at. As far as the right to appoint a manager is concerned, I would be very reluctant to advise a lay client to make an application of that nature on their own. I think specialist advice is required. Defective leases, again, as a transactional property lawyer, I'm highlighting the fact that there's a defect in our lease. Section 35 and Section 37 of the Act would allow an application to be made to tribunal to remedy the defective lease. Section 35 applications are quite limited in that the lease must be defective. 37 applications are wider. Application can be made where the majority of interested parties consent to the application. It doesn't have to be unanimous consent, majority consent. So if you have 30 leaseholders and a landlord and a management company, if 28 of the leaseholders want their leases varying on the basis that they are defective, you can apply under Section 37. Again, I would always advocate that a litigator takes the lead with regard to such an application. Purchase price following acquisition order might be a relatively simple task, and price paid under an application for right for first refusal. In essence, there we're being driven by valuation evidence, and there are valuers and surveyors that will take cases of this nature on through the tribunal and conduct the matter from start to finish themselves. And that may be appropriate. Again, it's driving down costs, and again, saving you as a transactional property lawyer from getting embroiled in disputes of that nature. Enfranchisement, Leasehold Reform Housing Urban Development Act, as I mentioned the notes here and then again on slide. Enfranchisement conditions and price to be paid to landlords. Lease extensions of flats, conditions and premiums to be paid. I'm fairly confident these days that most practitioners are aware of a calculator on the Leasehold Advisory Service website that permits the premium to be calculated with regard to lease extensions. It's a rough and ready calculation and formula, I give you that, but at the start of an application, it's useful to say to a client, look, you realize what this is going to cost. And again, tribunal has jurisdiction to determine reasonableness of landlord's costs. As far as making an application is concerned, we've covered most of these issues. I haven't mentioned reasonableness of administration charges. Important point. The tribunal has jurisdiction to determine administration charges that are fixed in the lease or claimed by a landlord. An administration charge must be reasonable. Quite interesting when you look at decisions of tribunal over recent years that, for example, fees for receiving notices of assignment, notice of charge, £25 to £50 seems to be the norm. Fees for retrospective consent for alterations, again, tribunals saying, well, it's not the nuisance value in demolishing the conservatory or the extension, it's what real cost does a landlord incur in providing retrospective consent. So you get a shock when you start looking at what a tribunal says is a reasonable sum for retrospective consent. Tribunal has jurisdiction to determine leaseholder breach as a prerequisite to forfeiture. Important point, I just had an email on this morning. With regard to forfeiture in connection with residential leases, there are a number of points to note. Firstly, if you are seeking a court order to forfeit a residential lease, there must have been a determination by a court or tribunal that the leaseholder is in fact in breach. Then and only then can you bring proceedings to forfeit. You can ask a county court judge to declare there's been a breach of covenant. You can ask a tribunal to do so. Little tip for you, a little word of warning. I came across this a few years ago. What some firms will do is they'll bring a money claim in the county court, a debt action for non-payment of service charge or non-payment of rent. They will get a default judgment in connection with that debt action and then deem that to be a determination of breach of covenant as a prerequisite to forfeiture. That's really outside the scope of the 2002 Act. The ethos in the 2002 Act is before you bring forfeiture proceedings, you get a tribunal or a court to look at the facts and decide there is definitely a breach. Then and only then can you forfeit. So this idea of bringing a money claim, obtaining a default judgment, runs contrary to that, because a judge or a tribunal has not determined that there's been a breach. It's just a paper administrative exercise for a default judgment in connection with a money claim. Service charge, we've covered all these issues. Is the service charge reasonable? Has it been apportioned reasonably? Remember what I said, you can't ask a tribunal for time to pay. All a tribunal has jurisdiction to do is to say that a service charge is properly due and owing on the basis that the service charge has been reasonably incurred at a reasonable cost. We've talked about service charge in the past and service charge issues. There's a little checklist there that I think is always useful for landlords or when you're dealing with service charge disputes. So is the landlord obliged to provide services within the lease? Can it charge for those services within the lease? Is there an obligation to consult? Can a landlord recover management fees? Remember what I've said in the past when dealing with residential leases. I don't like management fees that are a percentage of service charge costs. Why? Because in those circumstances, there is an incentive on the landlord to rack up service charge costs to increase the percentage of management fee that it can be recoverable. And service charge apportionment, again, if you're doing leasehold work, has anyone actually checked if service charge is apportioned on floor area or apportioned on value or apportioned on rateable value? Have we actually undertaken an exercise to see that the apportionment is fair and reasonable? And the tribunal has jurisdiction to determine who must pay the service charge. Again, with regard to service charge issues, Leasehold Advisory Service has some good guidance notes about challenging service charge. And remember, in the past, I've told you that service charge is only payable if a service charge demand is accompanied by guidance to leaseholders about their rights to challenge. Administration charges have to be reasonable. Again, Common Hold Leasehold Reform Act gives tribunals jurisdiction for that. This is the sort of application that can be made on written reps. Some practical tips here with regard to administration charges. Firstly, as a leaseholder, if you are in a situation where the landlord is demanding an excessive sum for retrospective consent, for example, you're going to say, I haven't got time to hold this transaction to let a tribunal determine whether the charge is reasonable or not. Whether it's reasonable or otherwise is irrelevant. I'm going to have to pay it. What I always advocate is that it's paid under protest. If you do that, you can then challenge it at a later date. If you just pay it, then the tribunal does not have jurisdiction to deal with the dispute concerning reasonableness or otherwise. The jurisdiction of the tribunal relates to grants of approval, provision of information, and costs arising in connection with non-payment of rent or service charge, and fees for retrospective consent. Some landlords, when they're looking at circumventing the rules related to administration charges, will immediately start alluding by email or post to the fact that they're contemplating forfeiture, and then recover all the costs that they incur on the basis that it was part of a forfeiture process. The courts don't like that. What the courts tend to say is you can only recover costs pertinent to forfeiture if you've actually begun the forfeiture process. Threatening or writing a letter saying you're going to forfeit does not trigger the recovery of costs via forfeiture provision. They would still be administration charges relating to costs arising from non-payment of rent or service charge or other breach of covenant. Legal costs. Again, as far as legal costs are concerned, if there are costs arising from a failure to pay or costs arising for breaches of covenant, they're deemed to be administration charges, and again are subject to the test of reasonableness. If a leaseholder agrees or admits responsibility to pay, then the general position is that the costs can't be challenged. They could be paid under protest, as I mentioned a little earlier. Lease extensions I've covered. A tribunal has wide-ranging jurisdiction to determine the terms of the lease, the premium that is paid, and issues of costs. With lease extensions, watch your valuation date. Make sure that you've got valuations as near to that date as is possible. be aware of the fact that it's possible to make applications for requests for information. If those requests for information are not complied with, application can be made to tribunal for an order for disclosure. We've covered service charge, talked about that. Varying defective leases. Section 35 to 39 of the 87 Act. The lease has to be defective. The lease has to be a relevant lease. Section, as I mentioned to you already, 35 deals with defective leases. As far as section 37 is concerned, the lease doesn't have to be defective as defined by the Act, but there has to be a majority of interested parties willing to allow tribunal jurisdiction to vary the lease. Section 37 gives you far wide-ranging opportunities to challenge defective leases. The beauty of the 87 Act is that you don't have to have a cooperative landlord. Landlord can just ignore you. Landlord can be distinctly uncooperative. You can make application to tribunal. Tribunal can order that the lease be remedied, either on the draft provisions provided in the application, or the tribunal can determine what the variation ought to be themselves, and that can then be imposed on a landlord. The matter can be remitted to a county court judge for a county court judge to approve the terms of the remedy and to sign the new lease or the deed of variation if appropriate. The right to manage. Again, lower tier tribunal has jurisdiction to determine qualification, to determine the extent of the property that is subject to the right to manage, and any other issues associated with right to manage applications. Interestingly, with regard to the right to manage, I've had a lot of experience of dealing with landlords and indeed leaseholders who've applied for a right to manage, and I frequently get a lot of dissatisfaction from leaseholders who tell me, well, the process was relatively easy, but at the end of the day, we've still got a nasty landlord to deal with, and all we've done is, in essence, created a new tier of bureaucracy. So right to manage applications aren't necessarily always a magic fix. They do, however, entitle participation, more participation in management issues via a right to manage company. There are model forms of application with regard to tribunal. You can get those on the Leasehold Advisory Service website. You can apply by way of letter. The party that is the respondent is entitled to make a response. The tribunal will normally declare what expert evidence is required. So it's a dangerous thing to immediately embark on obtaining expert evidence without a direction from the tribunal. Tribunals seem to like site inspections and will also, if there are matters that are matters of law, readily remit the application to a county court. Tribunals can make summary disposals on application. So if we are just simply arguing about the price to be paid, the premium to be paid on a lease extension, we could short circuit the process by a summary disposal application to tribunal. In those circumstances, the tribunal has jurisdiction to dispose of the proceedings, to dismiss the application and allow formal process to proceed, and in doing that will normally make case management directions. If a party to any tribunal application does not comply with directions, important to understand that tribunal may strike out a party's case. The party is normally given a chance to comply. It's not like a sort of county court application where you're given one chance and that's it. If you've got an application being made by a lay client, the tribunal tends to be a little bit more accommodating than a county court. But where professional advisors are involved, the tribunal's sort of jurisdiction, the tribunal's sort of orders tend to mirror what you see in the county court. Directions can be asked for by the parties. They can be made by the tribunal. If you are seeking a direction with regard to a lower tier tribunal, you must explain why you want the appropriate direction. The tribunal has wide-ranging case management powers. Some of those are quite interesting, allowing matters to be dealt with by way of written representation. That immediately starts reducing cost implications. It will also potentially reduce the time that is taken for disputes to be resolved. The tribunal has power to extend or reduce time limits, require witnesses to attend, can transfer proceedings or join proceedings. This is something that's quite interesting. If a tribunal has a number of applications of a similar theme, then you may find that all of those applications are joined to save time, to save money. And again, as far as that is concerned, the tribunal has quite wide-ranging powers. So it can often join proceedings of its own volition. The tribunal can order witness summonses for attendance, can order compliance with directions, it can strike out applications, it can bar participation, similar to sort of frivolous and vexatious litigants, and it can refer matters up to the upper tribunal. The next thing I want to talk about, this issue about withdrawal. I've emphasized this and I want to repeat it. Parties can give notice to withdraw, but consent of the tribunal can be required. Frequently, where there's a unilateral request made for withdrawal, conditions, namely relating to costs, will be imposed. And if parties have withdrawn, it is possible for the application to be reinstated. But again, it would be quite unusual for such an order to be made. Other issues, tribunals do like the idea of lead cases, so they will adjourn some cases and take a matter on for determination. The tribunal can transfer to the upper tribunal. There is something called a deployment pilot, which again is a system of sort of case allocation, which is quite useful and again is aimed at generating efficiency. You can have decisions without hearings, and of course the parties can agree terms and consent orders can be rubber stamped by a tribunal where appropriate. Parties will receive a decision notice from a tribunal after hearing or after written reps. There will always be written reasons given for a decision. There is always a right of appeal, and a tribunal has jurisdiction to set aside its own decisions where appropriate. Very important slide related to costs. When leasehold valuation tribunal proceedings were underway in the good old days, you would frequently see a tribunal being very reluctant to award costs against either party. These days, a tribunal has an unfettered discretion as to costs. If a party has behaved unreasonably, then costs can be awarded. If a party is seeking unilateral withdrawal, then costs can be awarded. The tribunal can award interest on costs and can make wasted costs orders. And as I mentioned, the trick that landlords frequently adopt is if they are unable to recover costs as part of the tribunal process, they will invariably recover that cost or put that cost into service charge. You can ask a tribunal to preclude such conduct. Before we finish today, I've given you a couple of cases that were heard this year. They are contained in the notes. Just out of interest, you've got Powell, which is the 2021 case that I first mentioned. And this is quite an interesting case that went before the upper tribunal, and it concerned certificates with regard to service charge. It's quite an interesting case. I'll just sort of go through the facts of it quickly. The position here was that leaseholders were arguing that service charges weren't payable because relevant accounts had not been certified by a chartered accountant as required by the lease. The freeholders' managing agents had provided a certificate, and it included a factual report by a firm of chartered accountants based on a limited review of material provided to them by the managing agents. So managing agents take the lead. Accountants are basically asked to have a look at the work that had been done to produce a report based on limited reviews of materials put in front of them. The first tier tribunal had a look at this and said that the costs that were billed appeared to be reasonable, but they would only become payable when certified accounts had been produced as required by the lease. Freeholder says, I'm having none of that, and appealed. It argued that the certificate produced by its managing agent was sufficient to satisfy the requirements of the lease. Additionally, relying on a letter from its accountants, the freeholder asserted that the accountant could only certify the accounts if it audited the accounts. Tribunal stressed the requirement for a certificate, and its form would be mandated by the lease. Great point that. It's something that is relevant to all leasehold disputes. What does the lease say? If the lease requires certified accounts being produced by a firm of certified accountants from central London, then that's what is required. Simple as that. I also, interestingly, as far as this case is concerned, highlight to you that the lease contained no requirement for service charge accounts to be certified, but the respondent's liability to pay, the leaseholder's liability to pay, was triggered by a chartered accountant providing a certified account setting out the lessee's share of total expenditure, the payments made on account, and the resulting shortfall or surplus. This hadn't been provided, so the costs incurred by the appellant were not yet payable by the lessee. Interesting case, just showing what a tribunal does with regard to mechanisms in leases, with regard to certified accounts or certification of accounts or expenses incurred by a landlord. And then I've given you Ashford against Mill Court Walton Limited. Upper tribunal decision, quite an interesting one, where we have some flats and some car parking. We have a situation where we wanted, as qualifying tenants, to acquire the flats and the easement to park itself. As far as that is concerned, there are a number of issues. The parties had agreed that certain flats in the building, flats 2 to 4, didn't contain an express right to park. But the nominee purchaser argued there was an implied intent of the parties relating to the original leases that parking would be permitted. The interesting case here was that the tribunal found the express words of leases were unambiguous. They didn't confer an easement to park, and therefore easement couldn't be implied. Car parking is a nightmare in connection with residential leases. It is absolutely essential that what you do in connection with a residential lease is determine whether or not there are rights relating to parking. In this type of situation, an application could have been made to vary the lease on the basis that the lease was defective, or an agreement could have been made to vary the lease before the process began relating to the acquisition of the reversionary interest by qualifying tenants. They sort of got things muddled up with regard to timing. Absolutely essential that where there are any form of implied rights, that those implied rights become express rights before application is made of this type. It is about 12 o'clock. We are looking at some question time. Robert, anything to add with regard to the points that I've made? While we're just waiting for Robert, what I would say to you is it's important from a residential transactional lawyer's perspective that we know what tribunals can do. Today isn't an open invitation for you on the basis that you're sick of residential conveyancing, and I can quite understand where you are at the moment, to jump ship and all of a sudden become a specialist litigator in connection with first-tier tribunals. It's not something that you can play at. The purpose of today is to highlight awareness with regard to jurisdiction. It's also to explain that there may be circumstances where you become embroiled in sort of on the edge or on the periphery, giving advice to applicants that are making application to tribunal as a consequence of the conveyancing process. And in short, with regard to that, you need to make sure clients are aware that you're not giving advice. And what I'm suggesting is you indicate to clients where they can seek advice. And to that end, Leasehold Advisory Service, Leasehold Knowledge Partnership would be my first 2 ports of call. Robert, anything to add?
Not really, Ian, but just a bit like you were saying at the end there. I think it is so tempting, isn't it, when clients ask you how to deal with a problem that you might have identified, to say there's a remedy. You can, you've got the right, you've got a restrictor covenant, you can enforce it, you can amend the lease, whatever. But that's not really the full information they need. They need to know timescales and need to have an idea of likelihood, don't they?
Absolutely. And I think, because of the Leasehold Valuation Tribunal being pretty relaxed in the past, a lot of practitioners think, well, the first tier tribunal is just a resurrection of that, and therefore there isn't any real vulnerability. So let's encourage our client to have a go. I don't think that's wise at all these days, because of the cost vulnerability and the fact that you can't unilaterally withdraw when you embark on it. The other interesting thing, Robert, is with regard to objections that are made to land registry applications, this idea that the land registry gives the parties a sort of 6-month opportunity to try to come to terms. Well, as I mentioned in my presentation, that's a charter to prevaricate and to delay and to create a nuisance. You can short circuit that by making application to tribunal. And it's important that clients are aware of that, because often the client will be left to deal with the negotiation process, perhaps in isolation, without any real advice. They might have a surveyor or an estate agent sort of sitting alongside, but they may not be prepared to pay you, and you may not be prepared to get involved in that with some justification. And therefore, to understand the process and to understand where the land registry is coming from is, I think, quite useful. It's a fascinating area, to be honest with you. If I was a property litigator, it might be an area that I start thinking about sort of specializing in, because I can only see more and more work coming along in this particular field. The interesting thing, however, is that the likes of common hold, the likes of leasehold reform is designed, will have a consequence of leading to less tribunal applications. That's certainly the sort of ethos of the government. Let's simplify the process. Let's create a system in common hold where nasty landlords are taken out of the equation. If we do that, then a lot of these applications will fall by the wayside. As far as common hold is concerned, I've heard nothing from the government in the last month or so after the big announcement on the 7th of January. So it's still pretty much wait and see. Stephen, question time. Is there anything to ask? Any questions posed? Any clarifications sought?
Yeah, of course. Yeah, it's a bit quiet on the questions front, and I think you've either explained everything too well or not said anything contentious this week, I think. But there are a couple of questions. Before we move to that, just a reminder to everyone that if you would like to submit a question, you can do so by the questions pane on your control panel. And obviously, we have a bit of time now for anyone that wants to stay for a quick Q&A session. While we're just waiting for some questions, we do have a couple. I'm just going to run a very quick poll. So the question is obviously in relation to today, the budget and SDLT. So regardless of the outcome in today's budget, what would you like to see the government do with SDLT in the future? So I'll just launch that poll now. The options are retain SDLT as it is, retain SDLT but exclude first-time buyers, retain SDLT but increase threshold to 500,000, abolish SDLT and replace with property tax, or other. And please let us know in the chat section if you do want to raise another option there. Yeah, so Ian, in terms of questions, the first question we have, how do I make it clear I object to landlord's costs so I can object later?
Yeah, great point, great question. If we're paying under protest, then you indicate this has been paid against my advice and under protest, and my client is reserving his position with regard to an application to tribunal or a court to determine reasonableness.
Perfect. Thank you, Ian. Thank you. And thank you to James for asking that question.
Yeah.
If my client wants to withdraw, I assume they can do, but will have the liability for costs?
Yeah, It's a great question. There isn't an automatic liability. The tribunal has jurisdiction to determine whether costs should be awarded or not. In the past, with regard to LBTs, people would just withdraw and there wouldn't be any issues with regard to cost. These days there could be. It's not automatic, Stephen, but there could be liability and vulnerability. It all depends, and what tribunals tend to do is look at whether or not you've behaved reasonably. And the problem with a unilateral withdrawal is, well, if you were the party that brought the proceedings, it's clearly unreasonable for you then to withdraw when you've allowed the other side to incur costs. That, I think, is your vulnerability.
Excellent. Okay, thank you, Ian.
Okay.
And thank you, Robert, for that question.
Yeah.
So yes, thank you to everyone as well for answering the poll during that. It's a small sample, but the clear front runner is to retain SDLT but increase the threshold to 500,000, which I think is quite sensible. That's pretty much what it is now, I think, Ian. Is that correct? But,
yeah. Interesting.
There is at least one or two people though that have clicked the other, and Megan has got in touch to suggest the idea that the rules are rewritten into a single code. The Welsh LTT is so much easier to follow. Ian, I don't know if you have any experience with.
I think Megan's right. That's a good point. If you do look at the if you've got time, there's the thing. If you have time, I think the Welsh system is better, is easier.
Absolutely.
It's quite interesting, you know. Often it's like I was doing some work on Common Hold over the weekend, and you look at the Scottish system with regard to their equivalent of leases, and it's just as good as Common Hold, but no one sort of looked at it or said, well, why can't we adopt that? I guess it's the same with the Welsh system. Megan's quite right. It seems to work. When you look at it, it seems fairly straightforward, certainly significantly more straightforward than our SDLT regime.
Absolutely. Thank you. And thank you, Megan, for that suggestion. Thank you. Just one final question. You know, I'm wary of the time. We want to wrap it up quite quickly today. So can you give an idea of the limits that the tribunal will put on costs?
There isn't a limit. There isn't a financial limit with regard to costs. Again, it all depends on your client's conduct. If your client has behaved unreasonably, for example, hasn't complied with directions, if your client is seen as being the equivalent of frivolous or vexatious, then there isn't a limit with regard to the cost that the tribunal can award against you. That's the problem. That's the problem. You see, it's great if you're conducting the litigation, okay? You can keep an eye on what's done or not done. But the thing that worries me, I'm a transactional property lawyer. I tell you, Stephen, hey, we've got an issue with regard to, I don't know, the landlord's administration charges. You should be making application to tribunal to challenge it. And I refer you to the Leasehold Advisory Service website. You get the appropriate forms, off you go. You may from time to time ring me to say, hey, you know, I've had this or I've got that, etc. I may feel some sympathy and some need to assist you, given that I've put you on this path. And the problem there is I don't know what you're doing or not doing. And the danger is that you don't appreciate the significance of a direction that's been made by the tribunal. You don't comply, your application is struck out, and then you're presented with a bill from the other side of £3,500 worth of legals on the basis that they've instructed solicitors to defend whatever your application is. That's what worries me, Stephen. Do you see the point?
I do, yeah. I mean obviously you say it worries you, and touched briefly on it in the presentation, but I mean, have you seen some examples of this that has it sort of?
I've seen awards for costs of £14,000–15,000.
Wow. Okay, yeah, that's a lot in anyone's book, I think, really.
That's a sting, isn't it? That is a sting. Yeah.
Absolutely, yeah. You know, I apologise. I'm going to do one more question because we have had one come through, and I think we're okay on time quickly. So, Claire asks, where the parties are in negotiation before a referral to the first tier lands tribunal, why can't this time be extended beyond the 6-month period in circumstances where the parties are in agreement?
I think the land registry will. If you drop me a note, I can have a look at it, but I'm fairly confident that if the parties are making progress with regard to communication and with regard to negotiation in that 6-month period, I have seen in the past additional time be allocated.
I think that seems sensible, doesn't it? Really, I mean, it's
Yeah.
excellent.
But remember, you can always, as an interested party, you can always say, no, I've had enough, I'm off to tribunal. But if we were sort of 5.5 months in and one of the parties is on holiday for 3 weeks and the other party's quite happy to wait to continue negotiations when they get back, I'm fairly confident that the land registry would extend time.
Perfect. Thank you, Ian, and thanks.
Yeah. Sorry, Steve, go on. There wouldn't be a risk of being sort of time barred with regard to an application in those circumstances.
Okay.
Yeah. Okay. Sorry about that, Steve. Yeah.
No. Thank you, Ian. Thanks. Okay. Well, I think that wraps everything up for today. So I'd just like to say thank you to everyone for attending and participating in today's webinar. If you have any questions, please do contact myself, Ian, or Robert. Once we leave today's webinar, you will receive an automated message from GoToWebinar. If you respond to this email, the replies come directly to me, and I can send any questions or feedback on to Ian or Robert, or try to answer any questions myself as well. You'll also receive a separate email from my colleague Robert Kelly, which will contain the slides and the notes for anyone that hasn't had them for today's session. So I'd just even say on behalf of Stewart Title, Ian, Robert and myself, thank you for joining us today and have a great rest of your day. Goodbye.